Hello. There are many reasons why undivided co-ownership or indivision is not recommended when you buy some property. It's not the same as condo, whatever your real estate agent might tell you. Uh, it's a significantly less convenient and more complicated property arrangement. Uh, so, of course, if you're already in there, you are in there. But if you have a choice, however attractive the price might be, there are several points to consider before you get yourself into that, particularly in Quebec. And it's not something unusual when, if you consult a lawyer about that, a lawyer would try his or her best to talk you out of this for many reasons. Uh, First of all, one thing which you probably should know or might know is that undivided ownership is sort of a relic of the previous times when condos or divided property uh, was not available. It was not in the code. It was not like properly made. So these undivided ownership agreements, undivided ownership itself, was sort of a approach, like a tool to achieve more or less similar results, so that one person or one family could still not own technically, but at least use exclusively some apartment in a larger building, like a duplex, triplex, so forth. Nowadays, when legal framework for a condo is all there and well established and well tested by the time, of course, it's much easier and preferable to go through that way. But there are many buildings which are still in undivided ownership, and because converting them to a condo, it's like multi-step process and sometimes lengthy, sometimes expensive, and more often, again, as one of the problems with undivided property, it requires cooperation of all the co-owners, and some of them do not want to get into those expenses and trouble, and some want, and there might be conflicts and so forth and so forth. So, still nowadays, especially with some old buildings, this undivided ownership still there. Sometimes it's like appearing naturally because somebody dies and there are many heirs, and a building that was initially in ownership of one person becomes, with every next generation, more and more split with respect to the title. The more and more the more and more problematic it becomes. So, at a certain point, if it was not sold altogether by all the heirs or next generation of them, the question of ownership agreement or just conversion to condo comes up, and it's not always timely for every particular co-owner, like 9%, 12.5%, and so forth, and to just organize them all. That's an event of itself. So, what's wrong or what's bad with undivided ownership? First of all, the very idea why it is undivided. Like, no one is owning his apartment or part of a basement or whatever. The owners, co-owners only get the percentage of the title in the whole property. So they all together own the whole property, and only by their agreement they sort of like divide by exclusive use inside, but it's between them. For the rest of the world, it's one owner split into chunks of the whole building. So, as you understand, when it comes to a decision about the whole building, like roof, walls, basement, plumbing, electricity, municipal regulations, and so forth, you need, again, cooperation of everybody to make the decision for an owner, because altogether you're owners. And if somebody is against that, and particularly if that somebody has a significant percentage of ownership, there might be a problem that you, having a lesser percentage, cannot even resolve on your own, being still responsible in part for the whole building, for non-compliance, for example, or non-payment, or lack of maintenance, and so forth and so forth. Many of those undivided properties do not even have co-ownership agreements. Many have, but very much outdated and not working in reality, because there are no meetings, there is no management appointment as it should. Paperwork is not done. So when it comes to a problem, because all the legal stuff is only meaningful when it comes to a problem. When there is no problem, like, everybody's happy without all that paperwork. But when it comes to a problem, who is responsible? To what extent? Suddenly you might see yourself owing like thousands and $1,000, like tens of $1,000, simply because something was not properly maintained or properly observed, and you didn't even know, and there is no one responsible because there is no building manager or board of directors or whatever. Even if it should have been by the co-ownership agreement if it existed. But again, very often you just bought what you thought is your share in the building, though in reality it's only a share in the co-ownership title, in the right itself. And maybe you asked and reviewed the co-ownership agreement. Maybe you didn't do that even. Maybe you reviewed it and then other neighbors told you that nobody cares, or some do care, some don't. And then you thought that it might be not your problem, but suddenly it might become yours. And for example, if you wanted to modify to make it like more modern, for example, this co-ownership agreement, or even to establish one when there is none, you might see a significant resistance of many others who simply don't want to bother. In that co-ownership agreement, if it existed, and it might exist from the times when it was split within one family, like decades ago. There are buildings of like the beginning of 20th century, for example. There might be preemption right there, meaning that if you want to sell, you first should offer, maybe exclusively, should offer it to the other co-owners, not to somebody outside. And that might affect the price, and to collect all the signatures and to negotiate with everyone might take time. So at the very least, it complicates if you want to sell. It gets even worse if it's not you who wants to sell, but, well, you pass away, then there are your heirs, and it's not clear who should own the title now. Are they obliged to sell to the other co-owners? Or maybe they are considered to be like a continuation of your ownership and so forth. And depending on the wording of that very much often outdated document, or if there is no document at all, there might be litigation, which is, again, costly at the very least, even if at the end you get what you wanted, and you might not. And it all comes to the fact that from the beginning, you don't have a right in a particular area of the property. You have only the right of a co-ownership right in the whole property. So it's hard to just get your chunk and go away. It's all interconnected, hence the problem itself. Same comes to a situation when you want to get the hypothec, a mortgage loan, credit line. And again, there is no chunk of a property that you can use for a hypothec, for a mortgage. It's just only a percentage in the total whole property right. So as you can imagine, the lenders, the creditors, they knowing all those problems, they prefer to have business like less uh, eagerly with this kind of property, and very often you can simply be refused or could not find good conditions or something acceptable for you and so forth. Or you sometimes, according to the co-ownership agreement, you might even need to run through all the other co-owners, asking them to get themselves into the same mortgage loan, which they most probably won't be happy to do otherwise, and so forth and so forth. Whereas even when you buy this sharing undivided co-ownership, you might later on find out that the previous seller or one of the previous sellers entered into some kind of this hypothecary agreement, a mortgage agreement for somebody else. And then suddenly you might find yourself responsible, being a new co-owner, but for the same share and so forth. When it comes, especially when it's an old building and it comes eventually to a necessity for significant and costly work, or maybe some new municipal regulations require that, as opposed to a regular condo where at least there should be a contingency fund or some other funds specifically for that purpose, here you might eventually find yourself facing a necessity to pay upfront quite a lot, not to mention some other payments which other neighbors of yours, other co-owners of yours, might not be even interested in paying because they don't have money, they don't care, they are not even there. Because very often it's not the co-owner who is living there, it's somebody who that co-owner let in, might be a tenant, might be a relative, family member, friend, whoever. So you don't even know where to go, and you might eventually face a situation when you have to pay for many others, or again face the consequences, which is costly and unpleasant and might require further litigation, which is again costly and unpleasant, and so forth. Sometimes in those undivided co-ownership agreements, there are strict limitations on what you can and what you cannot do with your area, because again, it's not yours. It's only in your use. So you cannot rent it out, for example. You cannot keep pets. You could not undergo some plumbing changes, for example, and so forth. And there could be many limitations, more severe than regular condo or municipal limitations, because again, they might go all the way back to the point when it belonged to one person, and that one person was splitting the property within his own family, so he or they together wanted to establish those rules which are natural and convenient to that family, and now 50, 70 years later, none of them is there, but the rules, and it's hard to change them, as I explained previously. So they might be still there, and there might be even one at, like, I don't know, 14% of the ownership, for example, or even 4% of the ownership. One unpleasant, not nice person who would just complain about everything and become litigious, and even though before everybody was successfully ignoring those limitations, then one would insist, and then by ownership agreement, you will have to let your tenant go, for example, and so forth. Not to mention that might entail problems with tribunal administratif de logement, the like renting board. And after all that, when you finally decide to sell it to get rid of all those problems, it might be difficult to find next buyer, at least next like good next buyer. So there might be on your part, or worse, even on the part of your real estate agent, might be a temptation to hide some of those problems, which will fight back later. Under the terms of vis cachet or just tainted contract. So you might be liable for quite some time after, even for something that you didn't even know because it was not originating from you, but from your co-owners and their tenants and neighbors and so forth. I'm not saying that you're completely trouble-free with a condo, for example, or you're completely trouble-free with your own, even small house. No. But in comparison, at least that's the situation for now, at least in Quebec, undivided co-ownership is the most problematic arrangement. So keep that in mind when you buy your property in Quebec, especially if it's your first property in Quebec, and especially if you come to that purchase with the expectations of your previous jurisdiction, where the situation might be different. So it might be a good idea if you hesitate and you're not satisfied with the flamboyant explanations of your real estate agent, to consult a notary, to consult a lawyer, to understand better what you're actually getting in. Thank you and have a nice day.